Welcome to the Judicial Committee of the Privy Council, where today we are hearing an appeal from the Court of Appeal of Trinidad and Tobago in the matter of Samsoondar against the Capital Insurance Company Limited. The appeal is being heard online because of the current pandemic. The appellant, Mr. Samsoondar, was the insured under a policy of motor insurance issued by the respondent company. The company paid sums to a third party following a road accident. The issue in this appeal is whether the company can recover those sums from Mr. Samsoondar. I'm Lord Lloyd Jones, and I'm sitting today with Lord Briggs, Lady Arden, Lord Leggett.
Good afternoon.
And Lord Burrows.
Good afternoon.
The appellant, Mr. Samsoondar, is represented by Mr. Navindra Ramnanan. The respondent, Capital Insurance Company Limited, is represented by Mr. Reshad Khan. Mr. Ramnanan.
Thank you, my lords and my lady. My lords, it is our position, it is the appellant's position, that the central issue in this appeal is the issue of whether the respondent in settling the third-party claim in 2007 did so under compulsion of law. The other issue is the issue on whether the Court of Appeal was right to hold that unjust enrichment was an additional basis under which the respondent could recover the sums. I would refer to that unjust enrichment issue as a secondary issue, and for reasons which I will demonstrate, is that whether that the respondent is entitled to recover under the principles of unjust enrichment is dependent on the first issue as to whether or not the respondent settled the third-party claim under compulsion of law. Now, I do not propose to go back into the facts, which have been set out quite clearly in our statement of facts and also in the submissions. What I would say, and what I would say that the respondent, in trying to persuade the board that the monies paid in 2007 was done so under compulsion of law, has a very challenging task in our respectful view. I would refer, my lords, to the case of the judgment of R versus Governor of Brockhill Prison. That will be the Court of Appeal decision 1999 Queens Bench 1043, and it's at tab 3.
Of electronic bundles, Mr. Ramnanan, so if you can give us the
Yes, I'm guided, my lord.
It's actually 236.
Yes, my lords would find it at electronic bundle page 243 and at paragraphs E to H. And where Lord Wolf states, the appeal raises issues of importance involving two principles which are deeply embedded in the law. The first is that any authoritative decision of the court stating what is the law operates retrospectively. Secondly, my lord, I now refer you to electronic bundle page 250. So it's the same judgment. And there, at paragraphs E to G, my Lord would say, it is stated, looking at the matter from the point of view of the governor, that may be fair and reasonable. And I think I do not, this is quite, I do not propose to go into the facts of this matter because this is a very prominent matter. But basically it concerns judicial interpretation of legislation which had changed and resulted in the appellant overstaying incarcerated for 59 additional days.
Yes, I think your point, Mr. Romnenan, is that the decision of the Privy Council in the earlier case on Section 2, subsection 7,
yes,
resulted in an interpretation of that subsection, which had always been the law.
Yes, that is correct, my Lord. Yes.
I think we understand that. We understand that.
Yeah. So I would not refer my lords to the other sections, which I had other parts of the judgment as well as of this judgment, which I had intended to, because it all speaks towards the same issue, which is that there has to be retrospective application of the decision of the Privy Council in the Risha St. Hill and presidential insurance matter. In fact, if my lords look at paragraphs 24, 25, and 26 of the respondent's submission, just a moment, if I can.
Lost that.
Yes, if my lords look at that is electronic bundle, page 181.
Yep.
Yes, my lords would see there's basically the respondent has conceded that there's retrospective application. If you look at paragraph 24, the respondent has no quarrel and accepts that the pronouncement by the Judicial Committee of the meaning of section 4.7 has retrospective application. And then he goes on 25 and 26 as well, conceding that there's retrospective application. We say quite simply, given the authorities we have put before your lordship, that once it is conceded that retrospective application, there's retrospective application of the Privy Council judgment, the Risha St. Hill judgment, then there's no basis upon which the respondent could say that it paid under compulsion of law. Now, at this stage, now this judgment, as my lords would appreciate, this judgment, the Risha St. Hill judgment, came down just before the pre-trial review, when the matter was before the trial judge. And what we say, what the appellant say, is when the correct interpretation of section 4.7 became known, at that point, the respondent ought to have properly considered what his case is, because the respondent now knew what the correct interpretation of section 4.7 was, and he could no longer maintain his case that he paid under compulsion of law. So at that point, we say the respondent had a decision to make. Now, if my lords have looked at the statement of case filed by the respondent in this matter, it is replete with references to an averment on an indemnity being claimed under the Act and under the policy. So notwithstanding my learned friend says in his submission, he cast his net wide, my lords would see that is not in fact the case. In fact, my learned friend casts his net very narrow in that he strictly came under the provisions of the Act and the policy. And to claim an indemnity under the policy and the Act, the only way the appellant could have done that, the respondent could have done that, is that he must have been obligated to pay the third party under compulsion of law. And Lord Legat.
Whether that's correct, Mr. Ramnath. In your case, you say there was no obligation to pay, therefore there was no authority to pay, more or less you say in paragraph 5, but the two are different, aren't they? There may have been no obligation to pay, but it doesn't follow that there was no authority to pay. So we have to look at the policy terms to answer that question.
Yes, and what we say is that the policy, I would have referred to the section under which the section which allows for the appellant to claim indemnification. That section, my lords, is conditional, it is contingent upon the respondent being having to pay the third party under compulsion of law. So it is only activated when the respondent has a duty under law to pay.
Well, maybe at some point, I'm not asking you to go out of your way, but maybe at some point in your submissions we could look at the policy and look in particular at the claims control laws, which, as I understand it, is the source of the insurer's authority to conduct the defence of and settle claims on behalf of the insured.
Yes, yes, ma'am. So it's our position that the appellant, sorry, the respondent could only claim an indemnity if it showed or demonstrated that it had to settle or it settled the third-party claim under compulsion of law. And it is our position, of course, that they did not do so. In fact, if my lords look at electronic bundle, page 89, my lords would see at page 89, there's a letter dated 10th April 2007 from the respondent to the appellant. And this was the first letter from the respondent to the appellant. And they took the position that they have nothing to do with this claim. They are asking the respondent to go and you should deal directly with the third party, which was indeed the correct position and the position they ought to have maintained. However, they did not do so. They went ahead, we say, without authorization, without a duty in law, without any compulsion in law, settled that third-party claim, and I refer to it as a frolic. They settled it on a frolic of their own. Now, what we say ought to have happened is that when the Risha St. Hill judgment was handed down by the court, the appellant, the respondent, ought to have considered its case at that stage and say, look, all right, when we paid, if they satisfy, if they can show that they paid under a mistake of what the law was, then they ought to have either done one of two things. Either they ought to have withdrawn their claim and file a claim against the third party and say, basically, we paid you this money. We were not obligated to pay you this money. We paid under a mistake. Secondly, alternatively, if as the respondent now contends they are entitled to recover on a restitutionary claim under the principles of unjust enrichment, then the respondent ought to have amended its case at that stage and say, okay, we have paid under a mistake, we paid settle the third-party claim under a mistake of law, and therefore we want to recover that money. We believe we can recover that money from the appellant under the principles of unjust enrichment. That was not done. The respondent maintained its position that it was claiming under 4.7, under the provisions of the policy and under the provisions of the Act.
These points to the Court of Appeal when they asked for submissions after the hearing of the appeal on the question of unjust enrichment.
I'm sorry, Lady Arden. Sorry to interrupt. We didn't hear the beginning of that.
Very good. Thank you, Lord James. I just want to ask whether you made all these points about what they should have done when the Court of Appeal called for further submissions on unjust enrichment. We haven't seen what you actually responded to the Court of Appeal, but at that point, did you point out that there was a pleading problem and that it ought to have been dealt with in another way in the court?
Certainly, my lady, and my lady would see that Justice of Appeal Rajendra Narayan, who handed down the decision, did not hold the view that unjust enrichment had to be pleaded, and he referred to the Moole versus Garrett authority. So that point was made quite clear to the Court of Appeal. Now, the difficulty the appellants had is because the respondent at that point said, we are maintaining this as our case. Then, in our view, the only case we had to meet was whether you can claim indemnity strictly under the terms of the policy and under the Act.
But you're effectively saying, so sorry, if I could just ask a follow-up, you're effectively saying the Court of Appeal was wrong to allow submissions in. And I'm not clear that this court can undertake to review that without knowing what you said and what the respondent said about that, because clearly the Court of Appeal didn't think it was an objection.
Yes, well, we my lady, it is in this issue of unjust enrichment was made in the course of our submissions to the Court of Appeal. So it was raised by the court on its own motion. The respondent never raised this issue. The court directed further submissions on it. We pointed out to the court in our submissions that no, you cannot raise this at this stage. It was not dealt with in the court below. The respondent continued its case on the basis of indemnity under Section 4.7 and the Act, and therefore you cannot raise the issue of unjust enrichment.
But did you indicate to the Court of Appeal what it was you would wish to have argued and adduced evidence on at first instance, if this point had then been in issue?
Certainly, my lady.
So what sort of points were they? What points?
I have mentioned it would be along similar lines as my lady would see in our written case, in which I had if I can just quickly if my lady look at paragraph 32. Of our case, that's electronic bundle, page 171.
I'm sorry, which part of 171?
At paragraph 32, please, my lady.
Yes, but are these the points that you made to the Court of Appeal?
Yes, yes, my lady. And my lady, what we indicated to the Court of Appeal as well is that it was not for the court in these proceedings to speculate and to determine what our defense would have been in proceedings had the third party bring a claim against us. We are entitled to a right to be heard in the matter, and the court cannot in these proceedings look at what our defense may have been or what it would have been, whether we would have had a defense or not. That is our right that we had, a right to be heard and to defend that claim, which would have been lost. And my lady would see in our witness statement, we raised several issues. One being that this appellant had 15, I think it was about 15 trucks licensed, insured with the insurer. He was obviously running a trucking business of which the insurer would have been aware. But notwithstanding that, they put all the policies for the owner, driver only. So they expected that Mr. Samsoondar would be driving all 15 trucks and running this trucking business by himself. So as I say, my lady, there are a number of issues we would have raised had we known that the case we had to meet. My lady would see that in the witness statement of Rajendra Samsoondar, he says the reason they went and filled out the claim form and the reason that they paid the excess and so on is because representations were made to them that Capital would settle the claim and waive the breach. And quite understandably so, because this would have been considered a very big client for Capital. And my lady would see it's a very small sum that is being claimed. So there were a number of issues that we would have raised if we knew that that was the case that my learned friend, that the respondent was going to take. My learned friend kept his case within the strict provisions of the Act and the policy. That having been done, the respondent, the appellant took the view, well, if this is the narrow case we have to meet, then the issue is simply what is the effect of the Risha St. Hill judgment, whether you paid under compulsion of law or not, having regard to the Risha St. Hill judgment. That having been done, the parties took a decision that why are we going to trial? This is just simply a matter of law. The parties then advised the judge that, look, we have no need to go to, we don't see the need to go to trial because the issue just hinges basically on what was the legal effect of the Risha St. Hill judgment on on whether or not the respondent was paid the third party under compulsion of law. It was a simple, very simple case as we saw it. And that is the case the appellant had to meet.
Thank you.
Now, notwithstanding, so we say that...
Lord Burrows has a question, I think.
Yes.
Yes. I've got two questions for you, if I may.
Yes.
The first is that in relation to the Court of Appeal judgment, there is a lot about damages for breach of contract, as if that was the primary claim. And at the moment, I'm not quite understanding how that fits with what you've said about compulsion of law. And secondly, and linked to that, I would just like to understand, when you say it was a simple case, are you conceding that if it was paid under compulsion of law, there is an entitlement to be to the indemnity an entitlement by the insurance company. Have you conceded that?
I am prepared to concede that, my lords. If it was paid under compulsion of law, then I would concede that not only that they would be entitled to claim under the policy, under the principles which I would come to shortly, as the respondent pointed out in his excerpt from Halsbury's laws, which made reference to Mole and Garrett. There is a possibility that he may be able to claim under unjust enrichment. And that, of course, that would be subject to whether or not it was properly pleaded, and whether it can be said that it was a definite benefit, a settlement of the liability to the, or what my learned friend refers to as a liability to the third party, whether that was a benefit to the appellant, because all it was at that point was a claim from the third party. Our position is that has not translated into a liability. It is simply a third party making a claim which can be defended, a claim on liability, and if not liability, quantum. So, but of course, if we concede that they would be entitled to claim under the Act, then the issue of unjust enrichment would not arise under the policy and the Act.
I should just flag, I'm having a little bit of difficulty with understanding the way you're putting it,
Yes.
because normally when one hears language of compulsion of law,
Yes.
you are actually talking about a particular type of claim within unjust enrichment, the Moole and Garrett type claim.
Yes.
So I go back to my first question, which was,
Yes.
what's all this about damages for breach of contract, which, as I understood it, was the primary way in which the Court of Appeal proceeded?
I'm not certain. I am not certain as to why or how the Court of Appeal arrived at damages for breach of contract.
So your position on that, you're just putting that to one side as, well, I don't know, is your stance that's mystifying and I'm moving on from it?
Yes, no, my lord, what I think the Court of Appeal may have been alluding to is that the Court of Appeal took the position that the compromise was made under the terms of the policy. They took the position that that capital was obligated under the state of the law at the time to pay to the third party, and that when they did so in accordance with their duties under the terms of the policy, and therefore when they came for an indemnity against us and we did not pay it to them, then we breached the contract. So perhaps that is how they arrived at breach of contract.
Yes, it would seem a peculiar claim to dress up as one for damages for breach of contract. One would then be, I think, talking about an indemnity. But
Yeah.
Your position is that that side of that rationale, damages
Yes.
for breach of contract, you are resisting and not accepting.
Certainly, my lord, that is our position.
Thank you.
Because, my lord, perhaps I should get into what I perceive to be the main source of error of the Court of Appeal. And that is the Court of Appeal erroneously construed the filling out of the claim form, the effect of the appellant filling out a claim form or the appellant's driver filling out a claim form and the appellant paying the excess. what the Court of Appeal construed as the effect of that is that the claimant, the appellant, was in effect making a request of the respondent to settle the claim. Now, that request, they seem to be suggesting, is in the context of the request that was made in the Court of Appeal judgment of Shiraz. If my lords look at just bear with me. If my lords look at electronic bundle, page 493. This is a matter from the court, a judgment from the Court of Appeal of Trinidad and Tobago. It deals with unjust enrichment, but I am specifically directing my lords to paragraph 3. And under numbers 1, 2, and 3, subparagraphs of paragraph 3, my lords and my lady would see this is the type of case where the claimant, the appellant in this case, was claiming that he paid monies to a third party because he was directed by the respondent to do so with an arrangement that he would be reimbursed, which is in effect a loan. Now, the Court of Appeal, what they seem to be suggesting is that when the appellant filled out the claim form and paid his excess, he was basically asking the respondent to pay that third party for me and I will pay you back, as if to suggest that he was seeking a loan from the insurance company. The policy and the relationship between the appellant and the respondent did not cater for that sort of relationship. There were one of two situations could happen. It's either the respondent pay under compulsion of law and he claims an indemnity. One. Secondly, the respondent is covered, the appellant is covered under the policy and he makes a claim to be indemnified for whatever losses he suffered or he's likely to be suffered. So the appellant, we are at pains to see how the Court of Appeal could have arrived at the conclusion that when the appellant filled out the claim form and paid the excess, he was making a request outside the terms of the policy, because that was the only thing it could have been if the Court of Appeal is correct. Other than that, when he filled out the claim form and paid the excess, what he would have been doing is making a claim to be covered under the policy. And in his witness statement, he said, this is what was done on the basis that they told him that they would cover the third-party claim. So in other words, waive the breach. They were waiving the breach and say, all right, you are covered. And that is why he would pay his excess. He would pay the 10% because if he was covered, assume the position where he did not breach the policy.
But how
Then
could they...
what would have... Yes.
I'm so sorry, I thought you'd finished. How could they waive a breach which they didn't know about at that point? They hadn't really appreciated the effect of presidential. Indeed, that comes later. So if they didn't realize that they were making a payment outside the policy, they couldn't be waiving any right that they had, could they? Because what requires informed consent?
Yes, my lady, if they held the position, the respondents held the position that the the respondent had breached the terms of the policy. So their initial position was, as I pointed out to my lords a while ago, in the letter of 10th of April 2007. Their initial position was, you settle directly with the third party. We have nothing to do with this. Subsequently, they would have decided, look, notwithstanding that you breached the policy, we are going to cover you. We get good business from you. We have 15 trucks insured with us. It's a small claim. We're going to cover you. So therefore, come and fill out your claim form, pay your excess, and we will take care of that.
It may be a little confusing to refer to it as breach, but what you're actually addressing is the fact that other drivers weren't covered under the policy.
Yes, that is correct, my lord. I know
it's been, this is my Lord Borough's point, that it's been said a number of times during these proceedings that there was a breach of contract. For my part, I have difficulty in seeing that it was a breach to allow someone else to drive in those circumstances. But we understand the point you're making.
Yes. So
please go on.
Yes, I'm afraid I was making the same point, that I struggle with your terminology here.
Yes.
On the face of it, there's no breach of contract. By allowing somebody who isn't authorised to drive, are you suggesting there's a breach of contract by doing that?
Well,
somebody who's not insured.
Yes, well, the conditions of the policy, allowed for the owner driver only. So only Mr. Samsoondar was entitled to drive. Insofar as he was not driving at the material time, the insurers, capital, held the view that that was constituted a breach of the terms of the policy. And therefore they will not, their initial position was that, well, their position was we're not liable. So it's either you settle directly or we settle because we are forced to do so in law, and then we come after you for an indemnity. So in respect, and that is where the issue of waiver came about. And that is why that was included. They seem to be, what they suggested to the appellant is that we'll take care of it, as if you were covered under the terms of the policy. And therefore, all actions that followed thereafter were consistent with someone who was covered under the terms of the policy. For example, if Mr. Samsoondar was driving himself, and that is why a claim form was subsequently filled out. And that is why he paid his 10%, or I can't remember the exact percentage, but he paid his excess because of course that would have been his contribution to whatever damages, whatever the claim was by the third party. So we are saying firstly that it cannot be construed as a request to pay as a request to capital to pay on the understanding that we will reimburse you. What it was and what it ought to have been construed as was that the appellant was simply making a claim to be covered under the terms of the policy and to be indemnified under the terms of the policy. And he followed all the steps that would be applicable if he was covered under the terms of the policy. Secondly, it was never the case, Lord Legard.
I just wanted to check the evidence on this, Mr. Ramnanan. On your client's statement, witness statement, on page 36 of the bundle, paragraph 9, there's the evidence he gives about payment of the excess.
Yeah.
Which I think is partly what you're referring to. Is that the only evidence there is on this? Is there any correspondence? Is it dealt with anywhere else, or is that it?
That is the evidence on it, my lords. I don't think it was a disputed fact. I think all the parties seem to accept, and the Court of Appeal, the courts below also accepted that and based their decision on the fact that the excess was paid.
You were also making an assertion just now that he filled in or submitted the claim form on the understanding that he was covered.
Yes.
Is there any evidence about that?
That when he submitted the claim form, yes.
He was led to believe that there was cover. Is there any evidence on that, or are you just saying that?
Save and accept the witness statement of Samsoondar, there is no evidence.
Well, what is there in his statement? What is there in his statement that supports it? I can't see anything except for paragraph 7 about the accident and paragraph 8. I can't see anything about the filling in of the claim form for it.
Not in respect of filling out the claim form specifically, but it says that he was informed that they were settling the matter with the third party and he would just be liable for the excess.
Okay.
Yeah.
Well, great.
And if my lords look at paragraph 10, I was previously led to believe by the defendant's representation that the claim was within the scope of the policy. And in reliance of these representations, I acted to my detriment by paying the excess requested by the defendant.
Is the claim form in the bundle?
Yes, the claim form is in the bundle, my lord. My lords would see that if I can, in the witness statement of Lynette Tarapasad, I'm getting the exact reference to my lord.
I'd be grateful if you could give me a page number for the claim form.
Yes, my lords, it's at EB 072.
72?
Yes.
Right. Thank you.
Yes. So,
and just help me. Who submitted the claim form? It looks as if it's by the employee of the appellant.
correct, my lord. It is a driver submitted this claim form. And my lords would see that we've said that this is not the type of claim in any event that a driver can admit. This is not it is not liability of the driver. It is a wheel flew off while he was driving and caused the accident.
Well,
but the point,
there may not be any evidence on it, but it isn't really believable, is it, that he submitted it without your client's approval?
no, we would accept that. We would accept it was because Mr. Samsoondar says that. He says that he was led to believe that they were settling the claim and they were and so on, and certain actions were taken. He doesn't refer specifically to the claim form, but I think yes, we can accept that. So the second point I was making to my lords is that it was never the appellant, the respondent's case that they paid the claim on the basis of a request made by the appellant. their case is they paid under compulsion of law. So by their very pleadings, they've accepted that there was no request to pay the claim. So therefore, the only thing we submit, what the appellant submit, is that the only conclusions that can be drawn from the filling out of the claim form and the paying of the excess is the appellant did this in the understanding or in the belief that he was making a claim to be indemnified under the policy and to be covered under the policy and not under any request to pay, and I will pay you back, because that is essentially a loan, as I submitted before. And there's no provision for that arrangement under the agreement between the terms of the contract between the appellant and the respondent. And we say, therefore, that it is this major, we see this as the main conclusion whereby the Court of Appeal may have fell into error and construed this, these actions as making a request to settle the third-party claim, not just making a request with the understanding that it was to be reimbursed, as in the Shiraz Ahmad Court of Appeal case, which I just referred my lords to. So, and to put it, just to summarize briefly, what we're saying is that these actions are the paying of the excess, the filling out of the claim form and so on, are consistent with someone who's making a claim to be covered under the policy. And therefore, it cannot be said unequivocally that this is a request to pay and be reimbursed, which in any event was not part of the appellant's case. Now, if I take, I just want to take my lords to electronic bundle 453. And at paragraph 9806, my lords would see, and the respondent relies on this, a restitutionary remedy lies against a debtor whose debt has been discharged by the claimant. To succeed in such a claim, known as a claim for recoupment or contribution, the claimant must show. Now, firstly, this is inapplicable to the facts of this case, because there is no undoubted or undisputed, the third party is not an undisputed creditor. So the defendant, the appellant at this stage could not have been said to be a debtor. All that was made was a claim by a third party. Secondly, the first factor listed there is that he was compelled or was compellable to make the payment. And we say, for reasons I've advanced to the board, to your lordships, he was not, the respondent was not compelled or compellable to make the payment. Secondly, that he did not officiously expose himself to liability to make the payments. And we say this is exactly what happened, because you see, they took, in the letter I referred your lordships to on the 10th of April 2007, they took the correct position. They said, you go and settle with the third party. And then thereafter, they go and settle the claim. So we say that when you look at factors 1, 2, and 3, because again, in 3, it says the payment, discharge, and liability of the defendant. And what we say is at this stage, there's no liability or no undisputed liability. there's simply a claim. And then the excerpt goes on to refer to the Moole and Garrett authority, which hinges on there being compulsion of law for you to recoup under these circumstances. So we say that quite irrespective of the pleading issue, that even if unjust enrichment was pleaded, then on the facts of this case, there was no basis for a restitutionary claim in unjust enrichment. And of course,
if the matter had been pleaded, wouldn't it have been necessary to investigate these matters at a trial?
Certainly, my lord. There would have been, these issues would have had to be investigated at a trial. And we say it's not the typical change of position defense that you see in the everyday unjust enrichment case. But the appellant, the respondent's position was changed by virtue of the settlement of the third party claim, in that the respondent now could not dispute this claim. The respondent could not dispute the damages. The respondent doesn't know how they arrive and on what basis they agreed at 43,000 as the figure. They could have just said,
the appellant does not, yeah?
Yes, the appellant. They could have simply said, well, we are agreeing to whatever figure you put there because we're going to recover anyway. So we don't know if it was compromise, if it was compromise in good faith, and all these are matters that change the respondent's, the appellant's position. And these were matters that would have had to be addressed at a trial. My lords, what I did in our written, in the written case of the appellant, I've gone through each of the findings of the Court of Appeal, and we've stated our position on how those findings are erroneous. The main one I have addressed, my lords, on, which is the finding that the payment of the excess and the filling of the claim form could only be construed as a request to pay with the understanding of reimbursement. So, unless my lords wishes me to deal with any of those issues, which the Court of Appeal set out as their basis for the reasons on which I have addressed in the written case, I do not propose to go there. Lord Briggs.
Could I come back, please, to the question which Lord Leggett raised at the beginning of the hearing? If you look at page 58 of the bundle,
58, my lord.
you see page 58.
Yes.
You see under conditions, clause 2, which provides that the company shall be entitled, if it so desires, to take over and conduct in his name the defence or settlement of any claim, or to prosecute in his name for his own benefit any claim for indemnity or damage or otherwise.
I'm not just my lord, I'm on page 58.
Yes.
Page 58. Under the heading general exceptions, condition, yes. Go
on down the page.
Yes.
Then you see conditions.
Yes, I'm seeing it there. Just a moment.
Then condition number 2. Which entitles, as I read it, the company, if it so desires, to take over and conduct ... the settlement of any claim And that means on behalf of the insured, that's your client, the appellant. The pleaded claim includes a claim for indemnity under the policy. Do you submit that this clause 2 is dependent upon there being an obligation on the insurer to pay, or is it independent of that obligation?
No, my lord, it's our position that this would have to be dependent on an obligation for the insurer to pay. Because this presupposes that you are covered under the policy. And therefore, if I'm covered under the policy, well then you can compromise on my behalf. And then so this has to be, because in order for the defendant, the respondent to take over and conduct in his name and defense or settlement of any claim, or to prosecute in his name for its own benefit, any claim for indemnity or damages, it has to be a situation where the company itself would have had to have some liability.
Yes, thank you.
Yes, so
You say that, sorry, to you as a matter of how you think the clause should be interpreted, how you say it should be interpreted? Because it just says any claim. Arguably, at least, that could mean any claim within the general scope of the policy, whether or not it is defeated by some exception or breach of condition or anything of that sort.
yes, what my lord, the appellant, the respondent's claim is that their duty arose under the Act and the terms of the policy. So what they're suggesting, the case is they're suggesting that under the Act, their duty to pay arose, and then under the policy, their indemnification, their right to be indemnified came about. It's a joint effect, they're claiming that is the joint effect of the Act and the policy. So what the respondent's case is that the obligation, first there was an obligation to pay, and then they are claiming indemnity which arose because of that obligation. So therefore, section 2, we are saying is not applicable to these proceedings, but in any event, we are saying that it contemplates a situation where there's coverage under the policy, where there's compulsion, where either the appellant is covered under the terms of the policy, or there's compulsion of law in respect of the respondent's liability to pay. Yeah, so my lords, I'm just checking to see if there's anything further on which my lords, unless my lord wishes to hear me on anything further, those are our respectful submissions.
Thank you, Mr. Ramnanan. Mr. Khan.
Lord, so this arose out of an accident in which there was an insured and an insurer. The insurer, we are saying, had a duty under the policy to pay the claim. The date of the accident would have been the 29th of July 2005. And some 1 year and 10 months later, the insurance company paid the claim to the third party. I don't think there's any dispute in this case that the payment by the insurer to the third party granted a benefit. There was a benefit that the insured, the appellant in this case, obtained by that benefit. And why we say that is under the interpretation of section 4.7 that was relied upon by the insurance company in May 2007 when the claim was paid. There was a duty to pay the claim to the third party and recover it back from the insured. That was the interpretation of section 4.7 that pertained judicially at the time based on the Corcoran judgment in Selwyn Benjamin. So what the law was? Yes, please, my lord.
No, we can't hear you, Lord Legate, I'm afraid.
Sorry. Can you hear me now? Yeah.
Yes.
Yes, please, my lord.
Your opening words were there was a duty under the policy to pay the claim. Now you've immediately gone to section 4.7, which is a statutory duty, if it's a duty at all. But can we just be clear, what is it in the policy that you say obliged your clients to pay the claim? Because I thought the position was agreed now that the claim is not covered by the policy.
So, if I may back up a bit, I do apologize. So, the situation in the accident was that the policy covered owner drivers only. There was an issue before the trial judge as to whether the policy itself covered owner driver. And the trial judge found that there was in fact a breach of the policy in that the insured was the only authorized driver. There was no other driver authorized under the policy. Under the dual effect of the policy and the avoidance of certain terms clause in the policy and the duty under section 4.7 of the Act, what Corcoran J found was that the insurance company had to pay the claim and recover it back from the insured. So it was in relation to both. Even though there was a breach of the policy, even though the policy was breached, in that there was a driver who was driving.
Sorry, can we just get the terminology right? Because there was no breach of the policy. There was no duty that was broken. The position simply was that the policy didn't only covered vehicles driven by the insured, and it did not cover, because of an exception, anybody else driving the vehicle. So it's not a question of breach. It's just a question that there was no right to be indemnified under the policy if anybody other than the insured was driving.
Well, the case proceeded all throughout, and I think the Privy Council in the Risha St. Hill judgment proceeded on the basis that, so yes, there was coverage outside of the policy. The policy terms covered the appellant alone.
Mm-hmm.
And therefore, the driving by Mr. Kurja was not covered under the policy. And therefore, the agreement between the parties, the contract between the appellant and the respondent was not upheld. And based on that, the insurance company was obligated in law, or we say was compelled in law, to pay the $43,400 to Tatil. Now,
well, that is that you've accepted that the Privy Council's decision has retrospective effect, so there never was any obligation under the statute or anything else to pay the claim.
Well, what we say is that the authorities raised in Kleinsworth and Duce Bank, we have to look at the state of mind of the payer at the time that the payment was being made. It's not, for example, when we say, well, there is retrospectivity, and therefore everyone is taken to know what the law is. and therefore there was no obligation or authority to pay in May 2007. The Risha judgment didn't come out until 2012, and Lord Gough and Lord Hoffman and Lord Hope in the Kleinworth judgment, even though that they were applying the retrospectivity, was saying that we must look at the state of mind of the pay, or when the monies were being paid, and whether they were paying the money pursuant to an understanding of what the law was, or in this case, pursuant to a judicial determination of the law. That may have turned out to be false, it may have turned out to be an error, it turned out to be a mistake. But the state of mind of the payer at the time that the payment was made is important. And my friend puts a full stop. He puts a full stop there and says, well, section 47 relates back to the date that the act was passed, and therefore it relating back to the date that the act was passed, there's no obligation or authority under the act to pay. But that's a comma. What is the legal? We have to go further and say, well, what are the rights and duties that arose from the payment? What happens to the payment? Is it recoverable? So it's not a full stop. Yes, please, my lord.
I could see the state of mind is relevant if you're putting the claim on the basis of mistake, paid under a mistake. But it's irrelevant if the question is, was there an obligation, and did I pay under an obligation? Once we know that section 47 means what the Privy Council said it meant, then there was no obligation. And the fact that the parties thought there was, neither here nor there. To that way of putting it, is there? There simply was no obligation under which the claim was made. If I think I have an obligation, doesn't mean I do. Just means I've made a mistake.
And therefore, if the mistake, if the mistake is made, what are the legal rights and duties? Is the party entitled to recover the money, to retain the benefit under the payment?
Is that the way you're putting the case? Are you accepting that you cannot maintain a case based on legal compulsion because there was no legal compulsion, and the only argument would be mistake?
The compulsion itself leads to the mistake.
No, it doesn't. It's the absence of compulsion that causes a mistake. It's the fact that there is no compulsion, which means that there was a mistake. If there had been a compulsion, then there wouldn't have been any mistake. He would have been liable to pay, and you'll be putting it on that basis. But it's for the very fact there was no compulsion that means there was perhaps a mistake. So it's one or the other. It can't be both, can it?
I think it can, please, my lord, because of the importance of the state of mind of the parties. The case has always been for recovery of the monies paid under the contract. My friend's argument that the case was only for the indemnity under section 47 is not correct. When one looks at the pleaded case is made under several bases. One being the contract and the breach, and I take my lord's point that money was paid outside of the contract. It was also under the indemnity, and under the indemnity and under the act, the monies were paid under what can be termed the misconception of the law, the erroneous misconception of the law, under the lack of authority, but it was paid because of the state of mind of the party at that time. And those are the facts that the claim as pleaded gives rise to. So the restitutionary relief, the relief for the repayment was always live in the case, and therefore under the compulsion, the compulsion argument, a comma has to be put there, not a full stop. Yes, please, my lord.
Order claim to recover on the basis of mistake. Is that a pleaded claim? Have you pleaded a claim that you're entitled to be reimbursed because the money was paid under a mistake?
Those specific words were not pleaded, my lord.
Any words to similar effect or meaning, such as a misunderstanding, error, etc. Is that put forward? I don't think it is.
What we pleaded over all the sufficient facts to raise that the monies were paid under the compulsion. It was paid for. And yes, please, my lady.
I'm sorry, I wasn't interrupting. I was just waiting my turn. Please finish the proposition.
What we are saying is that the law requires a party under Kleinworth, under the Duce Bank, to plead all of the constituent facts that could give rise to the restitutionary claim. And therefore, we are saying all of the facts in this particular matter to give rise to the recovery, to give rise to the restitution, to give rise to the recovery of the benefit obtained by the appellant was in fact pleaded. When one looks at the payment made under Section 47, yes, it was paid under a mistake of law. It was, and therefore the fact of the payment and the reliance of 47 and the retrospectivity of the Privy Council decision and research until is what made it the mistake. So therefore, all of the constituent facts of a claim for unjust enrichment had been pleaded as required and as was the point to be determined in the Kleinworth case. One of the questions that were put before the House of Lords in Kleinworth was the question of whether the facts as pleaded in the case gave rise to the mistake. And the way I recommended to my lords to look at it is whether the statement of case as a whole, whether all of the facts to establish the case in mistake or compulsion in any of the unjust factors, whether the facts themselves gives rise to the unjust factors or gives rise to the elements of unjust enrichment, as the Bendetti case said, being, has the defendant been enriched? And I think in the answer here is yes. Was the enrichment at the claimant's expense? And the answer was yes. And was the enrichment unjust? And the question of whether it was a mistake or not is a question of law. My friend raises, and in answer to the question, that we ought to have amended when the decision came out. Well, the answer to that is, what would we have amended to include? The only words we really would have amended to include would have been, well, when the payment of 2000 was made, it was made under a mistaken apprehension of the law. That is a question for the court to determine at the hearing whether the payment that was made a mistake, and that's a question of fact. And so any inclusion of the word mistake would have had nothing really to the pleaded cases. All of the constituent facts to establish the unjust enrichment was already pleaded.
All right, now Lady Arden has a question for you, Mr. Carr, and then Lord Burrow.
Thank you very much. Just going back to your point that for the purposes of recovering a payment made under a compulsion of law, made under that head, you would be able to take into account somebody's belief that they had a liability. Wouldn't you say that that imposes rather a large liability on a person who may not know another person is going to make a payment on their behalf under what they simply believe erroneously to be a liability? And my second point was really this. The words mistake, as I understand it, did not arise at the trial, and therefore the defendant didn't have an opportunity, sorry, Mr. Samsoondar did not have an opportunity of pleading those matters and proving those matters, which would have constituted defences to mistake, even if not defences to payments under compulsion. So in those circumstances, given that the whole purpose of pleadings is to elucidate the issues which need to be decided, surely there had to be clarity that you were claiming not simply for compulsion, but also on a restitutionary basis.
Thank you, Milady. So to answer the first question, is the payee, not a payee, but a payee or the benefit of the payment, the person who got the benefit of the payment in that scenario would have defenses to such a claim if, for example, it was paid without any legal basis at all. But where it can be demonstrated that it was paid under in the Kleinworth case, and Duce Bank, it was paid under a mistake of what the law stood to be by judicial decision or by settled law. In this case, it was by judicial decision. I don't think it arises that it would have placed too large a burden on the person who obtained the benefit. In terms of the second question, if I remember it right, I do apologize. In this case, what is clear in the statement of case, when the respondent in this case read the statement of case, it was clear that recovery under restitution, on those terms and so on, came to mind to the respondent, because in the defense that has been filed, be safe and except for the first limb, which is the breach limb, which they were saying that there was no breach, and it wasn't as Lord Leglatt had argued in the defense. They were saying that there was no breach, not because it was outside of the policy, but because the policy should be construed as covering Mr. Kurja. When you look at the alternative pleas, the plea of lack of authorization, erroneous misconception of the law, and mistake, it was raised by the defendant because all of the facts pleaded by the state in the statement of case raised those issues with the appellant. So the question being, well, they were taken by surprise or they didn't know, can't stand scrutiny of the defense itself, which raised the lack of authority. Lack of authority is an unjust factor. The question of misapprehension or erroneous misconception of the law is an unjust factor, and mistake as raised by the respondent. So the respondent recognized that mistake was part of this case as being pleaded by them. What it is they're saying is based on those factors, we don't have to do restitution or repay the monies. But again, we say, what is the legal effect of the erroneous misconception of the law? What is the legal effect of the mistake? And therefore, the answer to that question, milady, is that the case as pleaded gave rise, and clearly the respondent saw it, and clearly the judge at the first instance saw it. And I will agree that the case did not proceed under the full umbrella of unjust enrichment, but the spice of the benefit and detriment was alive in the case, as Justice Rahim spoke in his judgment at EB page 102 in his decision, that the defendant ought not to be allowed to benefit from the breach to the disadvantage of the claimant. The claimant ought not to be saddled with the burden for a liability which he had not agreed to undertake under the policy. So while the issues and the word mistake and unjust enrichment and so on was not specifically pleaded, and it is submitted that those words, and you don't require to plead the word unjust enrichment or injustice. I mean, as Professor Burke has said and cited in the authorities before the court, there is no freestanding cause of action in unjust enrichment. You don't have to plead unjust enrichment alone and the injustice. What you are required to do is to plead facts that give rise to the unjust factors and satisfies the test as detailed in Benedetti and so on. Has the defendant been enriched? And in this case, there is no dispute by the respondent that he's been enriched. Was the enrichment at the claimant's expense? There is no dispute from the appellant that is at the claimant's expense. And was the enrichment unjust? And the way that Lord Hope and Lord Hoffman and so on in Duce Bank and so on, and the way the tide in my issue submitted is moving, it's not a question of whether the appellant and the respondent in this case should retain the money. It's a question, yes, my lord.
Thank you, Mr. Khan. I'm just going to cut across slightly here
Yes.
because I think we're getting the message.
Yes.
And I just want to be clear that I understand the message. Your clients have succeeded in the Court of Appeal on the basis of a claim for damages for breach of contract or a claim for an indemnity under the contract. Now, as I understand it, you are not seeking to justify that line of reasoning. As I understand it, you are now putting your case entirely as a claim for unjust enrichment, which has got two limbs. One is that the claim is for legal compulsion, and you say one has to look at the time at which the payment was made in order to decide whether there was legal compulsion. Or secondly, you're saying that there's a mistake. And in relation to both of those, you're saying that there was sufficient pleading in general terms on the facts that they are permissible lines of inquiry. Am I right in understanding what you're now saying?
Yes, please, my lord.
Thank you.
Thank you.
And this is because there's an acceptance of the Kleinworth principle. There's an acceptance. Yes, please, my lord.
Leaving aside the pleading, on the question of mistake, A, is there any evidence put forward by your client that the settlement was made under a mistake? Is there any evidence that your client was mistaken about the law at the time? And B, how is that contention to be reconciled with the letter of the 10th of April at page 89, in which shortly before the settlement, your clients wrote saying that there was no cover?
Yes, please, my lord. Thank you very much. So the evidence of the evidence that there was a mistake in relation to the law, in my view, would be the payment itself, because the payment itself would arise under what the Selwyn-Benjamin interpretation of the case was. And it is important to note that the respondent in this case was the defendant in the Selwyn-Benjamin case. So they actually had a view on the law and took that matter to court and lost at substantial cost. Yes, the letter of the 10th of April speaks to itself and was calling upon the...
Mr. Khan, I think Lord Leggett's question is whether there's any evidence.
In the witness statement, it is not specifically addressed in terms of saying it was paid under a mistake, but it can be inferred from the facts of itself that the money was paid. It was said to be paid under Section 47, and therefore it must be under the interpretation of the law at the time. And one must remember that the Risha-Sinfield judgment was nowhere to be found at that time. The only operative that came in August 2012, some 5 years ago.
We understand that point.
Yes.
And Lord Leggett's second question, what do you say to that? How do you reconcile your case with the April letter?
Right. So the April letter says, and my friend is correct, it says it is saying, well, look, settle the claim with the third party. The compulsion arose because Tatil, since November 2005, a year and a half after the accident, was calling upon Capital to pay the claim. And had Capital not paid the claim, it is very likely that the action would be filed and there would be suit, and and they felt that they were compelled under the law to pay the claim. The reconciliation of the letter, yes, they're saying in the letter, we don't think we have to pay this claim, you go and pay it yourself. But having regard to the failure of the appellant to pay the claim, Capital was compelled to pay it to Tatil. Unreasonably so, we would argue, as the written submissions indicate. The other point I would raise in relation to that is there is some dicta in the Duce Bank case and so on that speak to even if there is the way we would say the tide is turning on unjust enrichment, even if there is a dispute as to what the law says. Even if there is a dispute, even if it is not exactly settled, and some would say pay and some would say not pay, the important question is whether it is just, whether it is conscionable for the defendant, for the appellant in this case, to retain the benefit. So the question is, was the money paid? Was it paid to the benefit of the appellant? And if so, is it just for him to retain that benefit? Now, I wish to say this to make this point clear. When the accident occurred, there were three parties. There is the insured, the insurer, and Tatil, who is making a subrogated claim. In all circumstances of this case, and in every interpretation of Section 47, the appellant was to be out $43,400. The Tatil was supposed to be plus $43,400. And the insurance company, Capital Insurance in this case, had to be net zero. Under the interpretation of Selwyn-Benjamin, Capital Insurance had to pay the claim, be negative, and then be reimbursed, be indemnified from the appellant. So in that circumstance, the person who had to be negative $43,400 was the appellant. In the Risha St. Hill version of Section 47, Capital never had to pay the claim, so Capital would have been net zero. The appellant would be the same, negative $43,400, and Tatil would be plus $43,400. So in all circumstances of this case, is that the appellant had to live up to its obligation caused by the accident to pay the claim. And and in this case, the appellant has raised no legal or other basis why they should not pay the claim, and why it is why any defense is why it is not it's unjust for them to retain the benefit obtained from the payment. Yes, my lord.
Well, apart from anything else, Mr. Khan, you haven't established that there was any liability to pay the claim, that there was liability arising from the accident. It's never been proved or demonstrated.
So, and that, yeah, what we would say in that regard, my lord, is the circumstances of this accident, the circumstances that gave rise to the payment is this. An accident occurred on the 26th of July, 2004. 6 days later, the driver came into the insurance company and reported the accident. My friend raises facts that it was based on representations and so on, and there is no such evidence before the court of any representation made by anyone in Capital Insurance that led to the report and the payment to the excess. What we have is on the 4th of August, and when one looks at the claim form attached to the witness statement of Mr. Prasad, it's at EB page 73. One sees it was filled out on the 4th of August, and mere 6 days later. Let's put ourselves in the mindset of when an accident occurs. The insurance company will know nothing about the accident until the party involved, the insured or its driver, its servants or agent, will come and make the report. And that's what happened in this case. They came in and they made the report and paid the excess, and therefore the insurance company became informed of the accident. And that's what the Court of Appeal is talking about. Where my friend spent a lot of time on. This was what were they doing? What they're saying is, I was involved in an accident. I have coverage by you. I want you to pay this claim. And that's all the Court of Appeal said. And that's a reasonable inference from the fact of the report. Yes, please, my lord.
I'm just going back at this point to your sort of plus and minus.
Yes.
And saying, well, your client ends up, Capital Insurance ends up $43,400 US or dollars worse off, and in some sense, the insured, by having saved that, is benefited by the same amount. Now, what about the excess that was paid? First of all, would you concede that that would have to be deducted?
Yes, please, my lord. That was never raised as an issue in the case, but the nature of an excess is the uninsured aspect of the claim. From that document itself that I referred to, I looked at it and it says that the excess is the sum of $2,000. I have not seen I have not seen any corroborating fact that it was paid, but I have no reason to doubt my friend in the witness statement saying that it was paid.
But you would concede that that would have to be deducted if we were with you?
Certainly, please, my lord.
Yeah. Then another linked question is, of course, from the insured's point of view, he's been paying premiums and he thought he was getting a return in terms of the insurer dealing with any claims in relation to vehicles that would be driven. So when you say, oh, it's not fair and it's unfair and unconscionable to retain the benefit, he thinks he's paid for that benefit, doesn't he? What's wrong with that as a proposition if we're moving into the realms of fairly airy-fairy, fair and reasonable and unconscionability?
Because he never paid for that coverage. He only paid for coverage for him alone to drive. And so therefore the premium that would have been exacted from him for that coverage was only for him alone. So and that issue was raised by him at the trial and was dismissed by the judge in that he was saying that, and the facts that my friend raised here in relation to 15 vehicles and what his expectations and so on were, the fact is that this was the coverage that he paid for and this was the coverage that he got. So there couldn't have been any premiums paid towards a coverage by Mr. Kurja or anybody else driving. That was just never part of the contract between the parties. And in relation to the form and what pertained in the mind of when the claim form was filled out, Mr. Kurja, when he came in, the liability arose from him saying that he was wrong in the accident. So the facts before Capital Insurance Limited, when the monies were paid, was that an accident occurred. The liable party is saying, I'm wrong in the accident. They came and filled out a claim form and they paid their excess and is making the request for us to pay the claim. Tatil has now said, yes, please, my lord.
The claim he was requesting you to pay was a claim under the policy. That's what the claim form was. He wasn't saying, please go and pay the third party for me so that I can pay you back, was he? He was saying, please pay me under the policy, or please agree that I'm covered under the policy. That's the claim. It's an insurance claim, not a road. He's not asking you to go and pay money for him just so that he can just float him over for a bit until he pays you. Wasn't asking you to do that, was he?
He was asking for coverage under the policy, certainly. But
exactly.
But that's again is a comma, because the coverage under the policy was conditional based on the interpretation of Section 4.7 that pertained at the time. So therefore, the insurance company will only know there is coverage when they go and they look at the policy. They will go and look at the certificate and see whether there is in fact any coverage at all, and therefore you would see in the document itself at page 72, entered in unauthorized driver's book. So therefore they would have gone and looked at the policy and see whether there was whether the claim that was being made that we were requesting to being paid was covered, it was not covered. And that's where the state of mind and the insurance and the liability comes in, because when they went and they looked at it and they considered what the law is, they would have come to the conclusion this was a claim we had to pay and recover it back. And why? Tatil was making the claim. Tatil was pursuing its claim since November 2005, 5 months before the claim was being paid. Tatil provided all of the documents in support of the claim. And therefore, in the state of mind of the insured at the time was, there is a claim that is existing. There is judicial law that says that we are compelled to pay this claim, and that the insured is wrong. There's no defense. And in relation to the point that my friend raised about a defense on liability, for a year and 10 months and up in fact quite until 2012, no evidence of that this defense has ever been brought. There is one small statement in the witness statement that is filed saying I had mechanic records and so on, but there has been no corroborating evidence of that at all that has ever been brought forward. And my friend is, and if we look at the an important point to raise in relation to Kleinwood and the retrospectivity is, if it is that we are to say that Section 4.7 related back to the time Parliament passed the law, that's a double-edged sword for my friend, and it cuts deeper on his side, because if Capital is to presume to always know what the law was, the appellant is always presumed to know what the law was, and the appellant ought to have always paid this claim to Tatil. A year and 10 months passed with Tatil making its claim, and the appellant did nothing. The appellant was happy to have Capital pay the claim and keep the benefits. And so that's a double-edged sword that relates back. The relation back, the retrospectivity, doesn't apply to the insurer alone. It applies to the insurance, to the insured, to the appellant. And we come back and we circle back again to the tide that Lord Hope and Lord Hoffman and so on speak about. Is it just for the appellant to retain the benefit? And
right.
yes.
Lord Briggs has a question, Mr. Carr.
Yes, please, my lord.
Mr. Carr, Lord Leggett and I put some questions to your opponent about condition 2 on page 58 of the policy document, page 58 of the bundle. The question was, well, if that created an entitlement in your client to settle any claim, did your indemnity arise under the policy because you had that entitlement under clause 2? And he said, no, that would only apply to a claim for something which was covered under the policy. Now, a little while ago, you answered Lord Leggett's question about page 89, which was your client's letter denying coverage. and you said, well, really, this payment wasn't so much made because it was an accident covered under the policy, but because of Section 4.7 of the Act. Putting those two together, do you challenge what your opponents said about the inapplicability of Clause 2? That's Clause 2 on page 58.
So my understanding of Clause 2 from first principles would be that Clause 2 will only apply to if there is coverage or obligation to pay under the policy or the act. So if it is that the insurance company had to pay the claim. So let's say, for example, it was a scenario where the recent judgment was in the state of mind of the parties or operative at the time in 2007, that interpretation, then the insurance company ought not to negotiate the claim and pay it. If, however, while it is that the accident, the driving at the time is not covered under the policy because of the operation and the interpretation of Section 4.7 triggered Condition 2. Condition 2, so therefore Condition 2 was triggered by that interpretation, and to cover and the whole point of that interpretation by Cokeram J was to say that it wasn't a defense to a third-party claim. The insurance company, therefore, must, under Condition 2, pay the claim. It must do so, and therefore Condition 2 became operative because of the interpretation of Section 4.7 that played in the mind of the insured at the time. Yes, please, my lord.
Thank you very much.
I understand what you're saying now about Condition 2. I just wanted to check, has Condition 2 featured at all in the argument in the courts below? Was it discussed in the High Court or Court of Appeal, or is it coming up for the first time now when we've asked questions about it?
My lord, I don't have a complete memory in relation to that. I know it was in the submissions in the Court of Appeal and so on. Condition 2, I think, was there, but it did not. There was no substantial argument. I don't remember any substantial argument on it.
Thank you.
Yes, please. And to answer a question that my lady posed to my friend in relation to what pertained at the time when unjust enrichment was raised by the court, I wish to say that it was right and proper for the Court of Appeal to raise the issue of unjust enrichment in this matter. All of the facts to raise unjust enrichment was already pleaded. None of the reliefs. So what really they were doing wasn't saying whether the cause of action arose. What they were saying was, can the recovery, can the payor, as they tied in Duce Bank and Kleinworth and so on, Lord Goff, Lord Hoffman and Lord Hope is saying, can the appellant retain the benefit based on all the facts that have been pleaded? None of the facts are inconsistent with the reliefs now being claimed. None of the facts are inconsistent with the reliefs being claimed, and therefore we're saying under the powers that the judges had under the CPR and under the Supreme Court of Judicature Act to raise any relief and grant any relief that the facts of the case give rise to, the Court of Appeal was right to raise. So, and what happened at the Court of Appeal hearing? What happened at the hearing was that at the oral arguments, after written submissions were filed, Justice Narayan asked the parties, both parties, whether the facts of the case gave rise to unjust enrichment. Very similar to the Shiraz Ahmad case, where the question was whether the facts of the case, it was a case in breach of contract and quasi-contract, whether the facts of the case gave rise to relief, to restitution or relief for the recovery of the money. And the parties were given an opportunity to be heard in that regard. I know as part of the settled record, though both submissions were supposed to have been before the court, because that was an amendment we requested, and I don't know if my friend provided those submissions, the submissions that were filed in the Court of Appeal to your lordships. My recollection of the settled record was those submissions were included there in manuscript. Yes, please, my lord.
Can I ask you this question? If we were with you in relation to legal compulsion as a general proposition, what are we basing our decision precisely on? In other words, we've been handed Moule and Garrett, or indicated that that's what one's talking about, but that might be thought to be a rather different situation. And in fact, I would go so far as to say that it exemplifies what is normally meant by compulsion of law. That is, where both parties have a legal obligation to pay to a third party. So in Moule and Garrett, as you recall, the landlord went against the tenant, but the tenant had actually assigned the tenancy, and the tenant was therefore able to go ultimately for a restitutionary claim against the assignees of the lease in the law of unjust enrichment. But our case isn't like that, is it? Because there's no question of the other, the victim of the road accident and or their insurer. They have no claim against capital insurance. There's no legal compulsion in that sense. Even in relation to, even if we were to look at it favourably from your point of view, that there is legal compulsion operating because of the non-retrospectivity that you're urging on us.
So in Trinidad law, the title can in fact in law sue both the appellant and the respondent together in proceedings. That came in as an amendment to the Motor Vehicle Third Parties Act. And therefore a judgment against both parties can in fact be obtained at the same time. And what we are saying is both parties would be jointly liable. And I will give by analogy an example of that. So for example, if it is that Tatil went on to get judgment against the appellant and the respondent under that provision of the act, they are joined as co-defendants to the action at the same time, and Capital Insurance were to become bankrupt, they can very well go after the appellant for the money for the same amount, and therefore the debt owed, the debt owed to Tatil would be a joint, in very much terms, joint debt. And under the Moule and Garrett principle, and while generally, and what it says, under the Bullen League generally covers co-mortgages and so on, the general principle that where the plaintiff has been compelled by law to pay or compellable by law, and we're saying they were compellable in law to pay by Tatil, because Tatil can go not only after the appellant, but can go after the Capital Insurance Limited at the same time and request the money.
What is the statutory provision, Mr. Khan?
Thank you.
I do apologize because I don't have it. I didn't expect that to arise. Section 10A of the Motor Vehicle Third Party Risks Act, Chapter 4851, I believe. My Lord, I can undertake to provide a copy of that.
That would be helpful.
I think we'd find that helpful.
Yes,
Mr.
I'm sorry, my friend wants to speak.
My lords, if I may interrupt to assist, the act is at in the electronic bundle. It's at tab 15. I can get the
Thank you.
electronic bundle.
And we've got it in amended form, have we? It's form.
Page 827.
Page 827 has the amended up to 1996.
Yes.
Thank you very much. Yes, Mr. Khan.
Yes, with my Lord, I'm just looking at the act for the provision.
Could I just have the page number? I've missed it. I'm sorry.
827.
827.
So the provision would be at page 841.
Yeah.
Yes.
Yes. So what it says is, if I may be permitted to read the section, where a plaintiff brings an action under section 10 against any person with whom a policy has been effected and who has had issued to him a certificate of insurance under Section 4.8 in respect of such liability as required to be covered by a policy under Section 4.1b, then even though liability is between the plaintiff and the insured has not yet been determined, or the insurer may be entitled to avoid or cancel, or may have avoided or canceled the policy, the plaintiff, being the third party title in this case, subject to the provisions of this section, join the insurer as co-defendant in this action. Part 2 of it says, where an insurer is joined as a co-defendant under subsection 1, the insurer may raise any defense he may be entitled to under the policy of insurance or otherwise. And it goes on to provide all the rights and duties.
So if in the present case, the insurer had been joined as a defendant, it would have been open to the insurer to say, insured wasn't covered under the policy for this particular risk.
Yes, it would have been open to them to say so. But in this particular case, having regard to the Selwyn, that's what exactly happened in the Selwyn Benjamin case. Capital Insurance did in fact say so, and went before Kokoram to say that based on our interpretation of Section 4.7, we don't have to pay this claim because Parliament intended. Well, that's incorrect.
That was on the old understanding of the law, which proved
that
incorrect.
that was under the old understanding of the law, and therefore, so the insurance company can raise those defenses if sued, and so therefore, a judgment, one judgment, is obtained against both parties in the case.
Yes, thank you.
My Lord.
Lord Burrows.
In respect of your second line of argument, so I'm assuming that your first line of argument is now legal compulsion. The second line of argument is mistake, and you're saying it's mistaken discharge of another's liability. Have you got any authorities that would indicate that there is such a claim for a mistaken discharge of another's legal liability?
What we are saying is the mistake would have arose under the interpretation of Section 4.7 itself.
I understand the mistake point, but what I'm asking you is, you've got an issue here. It's not a mistaken payment to the payee that you're claiming recovery of. It's the mistaken discharge of another's liability. And what I'm asking you is whether or not you've managed to unearth any authorities that would support that being a valid claim in unjust enrichment.
My Lord, in Kleinworth and itself, Lord Goff and the Lord Hope and so on did speak to where a payment is made to a third party and where the benefit goes to the person who is unjust enriched. So those cases are before the court do speak to where a party obtains a benefit by the payment to someone else. So, for example, in Moule and Garrett itself, the payment by the leasee to the leaseor was to the benefit of the assignee, and they were able to recover it from the assignee. It was always the damages was caused by the assignee itself, and therefore it was always the assignee's obligation to pay it, even though there was no privity of contract or privity of estate between the assignee and the leaseor.
I can see
he obtained the benefit of it.
It sounds to me that's an argument of principle. You're saying, well, there are different types of benefit. I'm just asking you, actually, rather more boringly, you might say, can you give me an authority that actually shows a case of mistake plus discharge of another's legal liability equals restitution?
No, please, my Lord. I don't have any at this time.
Okay.
The other point that we raised in the case and that my friend addressed was whether there would have been any fact-sensitive issues that could have been raised at a trial if unjust enrichment was specifically pleaded. We relate back to the argument that we've made that my friend saw, the appellant saw restitution as part of the case having regard to the way the defense is pleaded and the lack of authority and so on. And and specifically pleaded the issue of loss of chance. So let's deal with the loss of chance issue at the first instance. The argument itself says, well, if it is that Tattle had sued me, we would have been able to raise a defense in negligence. Fair enough. But that defense could have been raised it could have been raised in this action itself because of the loss of chance. And the loss of opportunity to raise a negligence defense can defeat a case of restitution. However, my friend raised the loss of chance defense, brought no evidence about it, filed a witness statement that gives uncorroborated statement. Well, we had mechanical records, and chose not to pursue that claim. At the trial of this matter, there was the issue before him wasn't a question of only law. There were questions of fact that the judge had to make determinations of, and that he did make. My friend chose not to cross-examine. My friend raised the loss of chance defense, which is a fact-sensitive issue, and chose not to pursue it. And that decision not to pursue it didn't come before the evidence, it came after the evidence. So the evidence was crafted in a way not to pursue the claim in the first place. So it's not competent for my friend to say that had Tattle filed a claim, we would have filed a negligence claim, because he had the opportunity to do it here and chose not to pursue it. The issue of the representations made, we've already dealt with that in saying that the representation.
Well, forgive me, before you move on, Mr. Ramnanan says that you were taking your stand at first instance solely on the point rising under Section 4, subsection 7 of the Act. And on that basis, if that was the sole basis on which you were presenting your claim, indemnity, then he was entitled to meet that by saying it was, as a matter of law, didn't run.
So, and we are saying that that submission is not correct when one looks at the statement of case itself. When one looks at the statement of case itself, which is included, which, one moment, please, my lords. When we look at EB page 9 and thereafter, the statement of case raises several areas in which the reimbursement was being claimed, the repayment was being claimed. One was for the breach of contract and the payment thereunder. Two, under the indemnity under the Act and under the policy. And three, there was if one looks at paragraph 17 of the amended statement of case, which is included at page 14, and this is where the alternative pleas by my friend would have arisen. And what we are saying here is that there were several other areas in which we were claiming reimbursement. One being compulsion, and compulsion under the Act. So when one reads further or in the alternative, the claimant claims the sum of 43,400 as being monies paid by the claimant pursuant to its compulsion on and or provisions of the Act. So that's a dual claim there, compulsion under the Act or provisions under the Act. So it's not correct for my friend to say that all we were claiming was the indemnity. There was live in the case at that time, the claim for compulsion under the provisions of the Act, and it must be under the provision of the Act being section 4.7, being the Cokeram interpretation, which would have played in the mind of the insured at the time. Richardson Hill was nowhere near the horizon at this time, and therefore it must be that under the Act means section 4.7. And then it goes on to say, at the direction and or request of the defendant, and therefore the case wasn't only under the indemnity, the issue of the payment being at the direction or request, namely being the filling out of the claim form, and this is the point the Court of Appeal was making, under the claim form and paying the excess, that they were requesting us to pay this claim for and on their behalf. And we go back to the point that in every interpretation of section 4.7 that my friend says applies retrospectively, it was the appellant's liability to pay. So he was asking us to pay a liability that was always his. It was never Capital's liability to pay, but he was making this request of us to pay that claim. And the last part of it is on behalf of him. It was his liability in all circumstances to pay. And so therefore, to answer the question, my lord, is that it's not correct for my friend to say that the case before the trial judge was just on the indemnity alone.
Right, got the point, thank you.
Yes, please, my lord. And therefore, in our written submissions, we go through extensively all of the fact-sensitive issues. And in relation to every one of those fact-sensitive issues, it was either directly raised by my friend in this case and not pursued, or he had the opportunity to raise it and he did not pursue them. And therefore, there were no fact-sensitive issues that there was the loss of chance to raise. And therefore, we are saying, even if a trial of this matter, even if unjust enrichment, so we are saying first, unjust enrichment, it was clear from the respondent's defense it arose. The appellant is just not accepting what the legal effect of that claim is, because lack of authority is an unjust factor. So if they're saying it was paid with lack of authority, well, so is it that they're entitled to recover it back? That is an unjust factor, and it raises unjust enrichment and the question of whether they're entitled to retain the benefit, a misconception or erroneous conception of the law. It is paid under that erroneous misconception of the law, but what is the legal effect of that payment? It was not a gift, it wasn't charity as under the Lipton Gorman principles. It wasn't paid, it wasn't given for consideration at all, because the premiums paid under the policy wasn't for that coverage. And therefore, it being paid under the misapprehension, well, what is the legal effect? The legal effect is, well, is he entitled to retain that benefit? And the word mistake comes from the defendant's case. If it is paid under a mistake of law, what is the legal effect? And Kleinworth says, once it is paid under a mistake of law, and whether there is the difference of opinion of what the law says or what the law doesn't say, once it is paid under that mistake of law, it is recoverable, of course, subject to the defenses of change of position. And there is no facts in this case at all that the defendant changed any position because of the payment to the third party. There was the money was paid to Tatil, and therefore he retained the benefit, and he still retains the benefit to this day, because it's a money payment of which he did not have to pay. And therefore, none of the defenses as detailed in Lipton Gorman applies in this case based on the facts. And my friend has raised none of those defenses. And in fact, what he says, it's not that he would have had good defenses to the case, but he could have raised fact-sensitive issues. The defense of change of position is not dealt with in my we submit by my friend. No facts certainly are raised by him to deal with the Lipton Gorman defenses to an unjust enrichment claim.
Thank you.
Those are the submissions, please, my lord.
Thank you. Are there any further questions for Mr. Khan? No, I think not. Thank you, Mr. Yes, my lady has a question.
I may be at error, but I couldn't find the submissions made to the Court of Appeal on adding submissions on unjust enrichment. It may be that I'm the only member of the court who hasn't found them, but if they're not in the bundle, I wondered if it would be possible to see them.
Can you
Milady, we can endeavor to send our submissions that were filed on unjust enrichment to the court. I don't have a copy. I looked for a copy of my friend's submissions that he says was filed, and I did not find a copy. So my friend will have among my papers. So my friend will have to supply that to the court.
Because I think you did intend it to be part of the record.
We thought it important for the court to see how we responded to what Justice Narayan had asked us to do. Justice Narayan asked whether the facts of the case. He didn't say at the oral hearing unjust enrichment arose. Can you recover? He said, did it arise? And he gave us an opportunity to address. And what we said in our submissions, based on the facts, based on the authorities as we saw them, all you had to plead. And I think it's an important point to make that under the Court of Appeal authority of Shara, of Jaiprasad and Ahmed, the question was, it was a case for breach of contract and quasi-contract, cases where monies were paid at the request of the defendant to third parties. And what the court had to do was whether the facts as pleaded gave rise to a claim for restitution. And the court went on to speak, relying on Bendetti and what we call the tide of Lord Hope, that the question was whether Ahmed, the defendant in that case, whether he could have retained the benefit. you see, and it's the same principle of Lord Hope and Lord Kleinworth and so on. And therefore, what we were saying, the facts of the case and what Lord Narayan wanted assistance on was whether the facts of the case, whether the four principles that one must plead under vendetta, has the defendant been, does the facts disclose that the defendant has been enriched? And in our submissions, it is clear in this case he has been enriched. Was the enrichment at the claimant's expense? We say it's clear that it was at the claimant's expense. Was the enrichment unjust for him to retain? And we say yes. The unjust factors being that we say we paid it under compulsion, and we say that we paid it under a mistake of law. And the mistake of law, we're saying we did not have to specifically plead those words because it arose from the facts of the case as it is. It was paid, and it is an agreed fact from my friend. My friend agrees in his submission that we paid it under Section 47 and under the interpretation of Section 47 that Corcoran placed. There is no dispute in the case that we paid it under Section 47, which turned out to be erroneous. And we again asked the court to look at the Kleinworth principles and so on in relation to how retrospectivity works and that the state of mind of the payer at the time operates. And once the court, in our view, we submit, agrees that the recovery of the money, and what we say is unjust enrichment deals with the recovery of the money. So it deals with the latter part of the case. What reliefs are you entitled to? And that's how Kleinworth works. That's how Jai Prasad and Ahmed was done. What reliefs?
Mr. Khan, forgive me. I think you've rather diverted from my lady's question, which is about what the Court of Appeal was told.
Yes, I do apologize. I took the opportunity unfairly so to digress. I do apologize.
Well, I suspect Lord Jones would be concerned to know within what time period these submissions can be sent.
Indeed.
We can have ours by close of business tomorrow. Today is Thursday here. Of course, your close of business tomorrow, which would be around maybe I assume at 11 o'clock a.m. our time.
Yes, that would be very helpful. Thank you very much. Mr. Ramnanan, you're muted at the moment. Can you start again, please?
Yes, my lords, I don't believe at the moment that I have a file copy. I may have an unfiled copy. What I would need to do is probably try to get it from the Court of Appeal as soon as possible, and an office copy from the Court of Appeal.
Yes.
And
well, that's going to take a little time. So how long do you need?
If I make the request just after the hearing today, I should say within a week.
Right. Well, we'll say you should both have 7 days within which to do that.
Yes.
Thank you very much.
Thank you.
There we are. Thank you. Now, your reply, Mr. Ramnanan.
Yes, my lords, my Lord Briggs had asked about while I was making my submission in respect of section of condition 2 of the policy. Now, as my learned friend indicated, he wasn't quite clear or sure whether it featured in the courts below that particular section. My recollection is there was no section 2, condition 2, never featured in the courts below. And that is why I was a bit surprised when it was drawn to my attention. However, during the course of my learned friend submissions, I got the opportunity to read section 2 properly. And as my learned friend indicated, it envisages a situation where the respondent or the insured is liable or potentially liable for to pay, and that gives him the right under the policy now to come and defend the claim, because the insured will be the person who has to ultimately pay the claim. So it is covering a situation like that. If my lords look at 2, if you look at the section, no admission, offer, promise, or payment shall be made by or on behalf of the insured without the consent of the company, which shall be entitled, if it so desires, to take over and conduct in his name the defense or settlement of any claim, to prosecute in his name for its own benefit. So for the benefit of the insurer. So that envisages a situation where the insured is facing potential liability. And therefore, of course, the insured would want to take over that proceedings and conduct it, because they will be the ones who have to pay at the end of the day. The appropriate section that should be of concern, or that is of concern in this matter, is, if my lords look a little higher on the page, that was page 58. 58. There is the heading avoidance of certain terms and rights of recovery. And that is the section that gives the insured the right to recover under the policy. And that is the applicable section. That is the section we say are applicable. And if my lords look at the last line in that section, but the insured shall repay to the company all sums paid by the company, which the company would not have been liable to pay but for the legislation. And that is where my learned friend's case is phrased, to get recovery under this section, because he's saying he's liable under the legislation, and this section gives him the right to recover. So in respect, that is just to clear up the issue or the appellant's position in relation to section 2, and what is the appropriate section under the policy. In respect of my learned friend made reference to certain pleadings that we would have made in relation to mistake and loss of opportunity and so on. What we did at the pleading stage, is that we were simply trying to alert the respondent.
I didn't understand that.
We were simply trying to alert the respondent that his case might be misconceived. And we specifically said in the pleadings that what he has is a case of mistake against Tattle, not against us. So we were intimating to the respondent at that stage, consider your case carefully, because on what you have put before the court, it appears that you have made a mistake and you have paid to the third party under a mistake. And that was the time for the respondent could have considered this case then and there. When we put in the statement evidence of what was told and representations that were made and what we could have said and so on, we were dealing with an issue of waiver, because one of our pleadings are that we were covered under the terms of the policy. So that we were saying that, look, even if you find we weren't covered, then you've waived the right to say that, because you told us we were covered. And that is the issue we were dealing with in the statement. Of course, when the Risha St. Hill judgment came down and they maintained the case as being under the terms of the Act and the policy, well then, we did not pursue those issues. In fact, I, dealing with the matter in the court below, said that this is a sure victory. That was our attitude, because he's going on 4-7. We now know the interpretation of 4-7, and he's maintained his case as being under compulsion of the law.
But there were other grounds pleaded. There were other grounds pleaded against you.
Yes.
Mr. Khan says he could have got home on another ground.
No, my lord. What Mr. Khan refers to is paragraph 17
Yes.
of his statement of case. But even in 17, it says in accordance with the policy and the Act. So even though it may, there's he's framed it and or request and or. What he says in accordance with the terms of the policy and the Act. So in every material pleading in which he's setting out his right to this indemnity, he's made reference even in section 17. And I indicated that to my lord, that is the section he says he's cast his net wide. But when you examine the section, he's yet again confined himself to under the act and under the policy. And that has to taken to mean he was coming under his right to recovery under the policy, which is the section which I just drew your lordship's attention to. In relation to my learned friend raised the issue of section 10A under the Act, the Insurance Act, we say that that is totally inapplicable. And section 10A covers a situation. You can bring the insured and the insurer as co-defendants if the insured has liability under section 10A. So there are certain breaches that the insured cannot avoid liability for. I think, for example, one of them is the age restriction or the number of persons in the vehicle. Things like that, the insured can't avoid liability. So you can bring the insured and the insurer as co-defendants. Not in the case of 4.7. In the case of 4.7, there would have been no claim against the insurer, and the insurer would have been entitled to apply to strike out the claim as against it if Tattle had brought the claim against the insured and the insurer. And as we said, that if they accepted the law, they accepted Justice Kokaram's interpretation of the law. They could have done as Presidential did and challenged that. Or they could have done as Samsoondar did in this case and say, no, that is a mistake. That is not the law. You were you brought this on what you thought was the law, or what you believe the law to be. Assuming that is what he did. But the case is, his case is that he was entitled to compulsion under section 4.7. I'm just looking to see if there's anything else. A number of matters that my learned friend has raised that we could have explored in the in this case, in terms of what evidence that we had to show that we would have been able to defend the claim and things like that. We say that simply does not arise on this claim. Had you brought the proper claim, and that is where we say the Court of Appeal went wrong, because the Court of Appeal engaged in a speculative exercise to determine what would have been our claim. Had Tattle filed a claim against Samsoondar, Samsoondar could have gone to his attorneys. It's a negligence claim. They could have said, well, do you have proper records? Can you show you maintained your vehicle? Or did you go somewhere and they put on the wheel and left it slack, and that is why it flew out? Or that would have been a matter to be dealt with if the claim was brought against him. It is not an exercise to be dealt with in this claim. That he does not have to meet that claim here. So we would have mentioned fleetingly, you know, there are certain, he would have lost opportunity to defend the claim. And what we hinge substantially on is a breach of natural justice. He has denied the right to be heard. So however weak one may think that his defense might have been, he is entitled to put that defense forward and be heard on it. And it is not for the Court of Appeal, it was wrong for the Court of Appeal at this stage to say he could not defend that claim. Because when the claim form was filled out in the respondent company, what would normally happen is if the respondent decides this is a claim in which we will cover it, then the respondent will now refer the matter to their attorneys. They will take comprehensive instructions and decide whether there's a defense or not to the Tattle claim. They will take over the matter as under section 2, condition 2, which Lord Briggs pointed out, and they will now decide whether we can defend the claim or not. So this is not the type of claim that a driver could come in and just say, well, you know, we're wrong in the claim. This is not a situation where he himself was negligent as the driver. This is a situation where a wheel flew off, and therefore it is something that, you know, they would have had to, either the insurer, if he's considering, if they are taking on the claim, or if they are covering the claim, or Samsoondar, if he was defending the third-party claim, would need proper legal advice as to whether or not they can defend this claim and whether they have a realistic prospect and so on. And that was lost, the right to be heard. And that is why it was mentioned in that we never sought to prove in these proceedings what our defense was and that it would succeed. What we are saying is we simply lost that right to get that opportunity to defend the claim. Even if we didn't have a claim on liability, what about quantum? We could have challenged the sum of 43,000 as contended by the appellants. So in respect of, I'm just checking if there's anything else. I don't think there is. So unless my lord wishes to hear me on any other issue, that is my respectful reply.
Mr. Ramnanan, what relief are you asking us to grant if you succeed in your appeal?
To set aside the order of the Court of Appeal and to dismiss the claim of the respondent.
Thank you very much.
Yes, thank you.
Any further questions from Mr. Ramnanan? Yes, Lord Burrows.
Can I just push you on that? You're saying to dismiss the claim, but if one of your central arguments is that there was insufficient pleading,
yes,
and you didn't have an opportunity to meet the case, might it be said that it should, if we were with you, go back for those issues to be properly pled and dealt with?
No, my lords, we respectfully do not think that would be the appropriate course. That would be an abuse of process, because the law and the civil proceedings rules, it require you to deal with all issues that can conveniently be dealt with when they can conveniently be dealt with. So that my learned friend has elected a certain course. He has gone, this matter has gone to judgment. It's gone back to appeal, and we don't respectfully do not think that it's open to him now to change that, to change his case to that, because that is an action he ought to have taken when, and the rules and amendments in our jurisdiction, I know it's more restrictive certainly than in the UK, under the UKCPR, and it requires that you have to move promptly and so on when you are amending your case. So it cannot be, the respondent can get a second bite at the cherry. He chose his path, and he must be confined to the path that he chose, my lord.
Thank you. And then the other point I wanted to ask you was really a point of clarification. You took us in the policy of insurance to the sentence under avoidance of certain terms and right of recovery.
Yes.
And you pointed to the sentence reading, but the insured shall repay to the company, etc.
Yes.
And my understanding of what your submission was that when arguments had been put about legal compulsion, it was that clause of the policy that was particularly in mind. That is, whether or not there was liability to pay, but for the legislation. Is that right?
Yes, because apart from the wording of the clause itself, it is really the only clause. This is the part of the policy that deals with the insurer's right to recovery, and it sets out clear and unambiguous terms what is the situation that will arise under which you would be able to claim an indemnity.
So paragraph 17 of the statement of case
Yeah.
when it refers to compulsion, was it your understanding that that was a claim by reason to this clause under the contract for an indemnity, or was it your understanding that it was a claim in unjust enrichment?
No, under the policy and the act, yes.
Thank you.
The unjust enrichment never featured until late in the hearing before the Court of Appeal. Never. At no point.
Thank you very much. Very well. And that completes the argument in this case. We're very grateful to counsel for their very helpful submissions. We will take time to consider our decision. The hearing is now adjourned. Thank you very much. Now concluded. Thank you very much indeed.